All right, I'll try again. You all don't have to respond to me, but good morning, everyone. I forgot because I'm a little rusty to connect to Zoom. So I was having a great time up here on the bench, and I realized that we may have some people who are appearing virtually. So we're working our way through the plea and arraignment calendar. I had already heard from Ms. Feely that her office will be representing, she will be representing Ms. Bennett. Ms. Taylor, who is a co-defendant to Ms. Bennett on position 2. And I have to change my name. Sorry. Needs a different lawyer. I see that Ms. Eustace real briefly represented, at least that's the name on there for Ms. Taylor, but your check of it, Ms. Feely, is that that doesn't create a problem for you representing Ms. Bennett. Great. Okay. I'm at peace with that. I think that makes sense. So Ms. Nelson, does this mean that we will reach out to well, let me start. Ms. Taylor, do you need a lawyer appointed to represent you, or were you planning on hiring your own attorney?
Well, she was supposed to be representing me, and then all of a sudden it changed, so I'm not really sure. Okay,
well, supposed to, I mean, that may have been your expectation, but the public defender's office can only represent one defendant in a co-defendant case?
And she asked me first, so she said she was representing me. I don't know what happened between here and over there.
Okay, my guess is it had to do with the fact that Ms. Bennett has a second older case, and the public defender's office had already plugged in with Ms. Bennett then, and that's why. But we are where we are. My question to you is, still need appointed counsel. Well, we're going to line that up. Ms. Cabrera will likely be that lawyer. She is generally the person we turn to for when we're looking for what we call conflict counsel, not meaning someone has a disagreement, just that the public defender's office would have a conflict if they represented both you and Ms. Bennett. So we're going to reach out to Ms. Cabrera, who I think should be here today because, at least virtually, she's got a client on the calendar who's picked up 3 more armed robberies. So let's start with Ms. Bennett. Is Ms. Bennett waiving arraignment?
We are, and the reason is because of the TSR.
Okay, great. Let me check one thing, Ms. Bennett, about your cases. And Ms. Clark, good morning. How are you? Happy New Year. Are these going to be line ADA cases? They're not. I saw like Brad Malkin's name on one of them, and that made me think, oh, white collar.
So those will actually be white collar division, and Jonathan Salmon is on.
Good morning, Your Honor. I'm on the line. It will be handled by the white collar crime unit. So I'll be
great. Mr. Salmon, how are you? Happy New Year.
Happy New Year. Thank you.
So are you handling both of Ms. Bennett's cases? I see your name actually listed as state attorney for the first one where Ms. Bennett has no co-defendant. So you're handling all 3 matters, 2 cases, but a total of 3 positions on the calendar. Is that correct?
That's correct, Your Honor.
Okay, great. So let me get back to what I was going to check here for Ms. Bennett. Mr. Salmon, is there anything strange or extra voluminous about discovery? Any reason why you'll have any delay in getting discovery to Ms. Feely in the 2 cases of Ms. Bennett's?
It won't be an issue at all. I mean, we could get it by next week, certainly.
Okay. Well, I'll be entering a scheduling order, and that's going to give you a deadline for discovery. It sounds like you'll have no problem meeting, and then there'll be a deadline for Ms. Feely to file any motions if she has any that she thinks she needs to file. Okay, so this came to us because it is alleged that one of the defendants is a repeat offender. Okay, let's try to figure out why this left non-complex. Got it. Ms. Bennett, I want to make sure we are able to keep track of you. Do you still live on Plantation Drive?
Yes.
Okay, you're going to get mail notification, meaning in the mail, when you need to be back in court. So if you move, you got to let Ms. Feely know, and then she can notify the clerk's office and we'll get a new address. Have you given Ms. Feely good contact information? Or maybe that's what she needs to follow up with you. She'll need a cell phone, an email address, so that she has no trouble tracking you down.
That's not a problem. However, I have been calling the public defender's office for like almost a month. And it was very difficult getting in contact with someone. All the information that I was receiving was incorrect, even to the point where I had to contact my ombudsman. They said that one of the cases had not been entered, had not been indicted by the grand jury, or they didn't present it to the grand jury. Now I'm finding out that the case with the co-defendant is the case that was not supposed to be presented to the grand jury, and then we're here and it's been presented.
So that may be a discussion that Ms. Feely will want to have with Mr. Salmon, but only the district attorney's office decides whether something's going to be presented or not. It's not I don't tell them to or not to. The defense attorney doesn't. And clearly they presented it to the grand jury because there are two indictments now, one with you and Ms. Taylor, and then one that's just you. And you're going to have the same lawyer for both. These cases very recently bounced from the non-complex division, where it's a completely different set of lawyers. And so I'm not making excuses. It sounds like you were justifiably frustrated. You are in good hands now. You're going to have a direct dial number for Ms. Feely. That's who you should reach out to with questions. Before then, my guess is you were being bounced around between folks who either were transitioning, because non-complex is an area where there's some turnover, sort of where lawyers first start out and then they get promoted into other courtrooms. Plus, your cases then got moved from there. And so someone looking in the system would say, well, now you're in a whole nother courtroom. There's no lawyer did anything wrong. It's just it was brought to Judge DeFore. That's the judge who had your cases before. It was brought to his attention that you supposedly have a sufficient criminal history that our rules are that your case should be in front of an elected judge. I'm one of those. So that's why your case is moved. I don't know if you've got another one. There may be one that didn't get presented to the grand jury. There could be another case out there. What I know is that you've got two that have been indicted, and they're both with me. Ms. Feely is going to, it sounds like, be waiving arraignment on your behalf, which is simply her filing a piece of paper that says that Ms. Bennett pleads not guilty. That will trigger a scheduling order, which will set the deadline you already heard me talk about, where Mr. Salmon needs to get discovery to your lawyer. She'll sit down with you and say, here's what they got. This looks really good for us, or this looks really bad for us, whatever it is. And then you and Ms. Feely will start talking about what's the best way to move forward. Is this one where we want to get with the prosecutor to see if we can work something out, or we fight this because they got the wrong person, or I've been framed, or I was in Texas? You're going to have, your version of events. There's always two sides to the story. And I'm here to deal with whatever flows from all that. If we need to have a motions hearing because your lawyer wants to try to exclude something, we'll do that here in court. If you and she have worked something out, we'll come in here and take the plea. And if it's going to be a trial, we'll do that. My goal is to keep it moving. I don't know, I'm going to pop open one of these, how old any of this alleged conduct is, although I know now. One of these is stuff from allegedly 2021. That's 3 years old. So it's time to sort that out. Either make it go away or you own up to it, whatever the decision ultimately is. Mr. Salmon will need to be moving it forward, and Ms. Feely will be there on your behalf. Ms. Feely, anything else in Ms. Bennett's cases? All right. So Ms. Bennett, I'm going to ask you to stay here until Ms. Feely has a chance to connect with you one more time. When she says it's okay for you to go, you are free to do that. And that's all I've got for you, unless you have any questions for me.
No, I have no more questions. I just call the clerk's office like every 3 days because I know that things change.
Yeah, you won't need to do that anymore. The next time you come to court, it's either going to be because we're arguing a motion that your lawyer filed, or we're working your case out. Okay, so there will be be less of a need to. You're welcome to keep calling the clerk, but calling Ms. Feely will be the way to go. Okay. All right. Let me see, Ms. Taylor, if I have any updates for you. Ms. Cabrera is not available today, so she is going to be checking. She was reachable by phone. She is checking with her supervisor to see if she can be assigned to your case. If so, she can either connect with you and you all can waive arraignment, which is what Ms. Bennett just did, or you can come back to court someday soon. I'm fine with that. We'll have this conversation right here.
That creates a hardship for me, because someone had to bring me, so whatever we can establish today, I appreciate it.
Okay, well, let me look at your case and see what we've got. Wow, the allegations in the case you've got with Ms. Bennett even older, from June of 2020. All right. So I've got an address for you in Powder Springs, is that correct? On Tedford Court? I can't hear when you nod your head.
Yes.
Okay, got it. Because there's also a Boulder Road address, and we're going to send it to one of the places. And if we send it to the wrong place and you don't show up, that's on you and not on the court. And then I sign a warrant. So what address should we be using, the Powder Springs or the Boulder Road?
I've updated the court with the most recent. I sent them 2 days ago, so they have the most recent.
So I'm looking at the court, and my question again is, should we use the Powder Springs address or the Boulder Road address? Powder Springs. Okay. I'll make sure that's what happens. And we will have, I guess if you want to give Deputy Gordon your contact information, we can pass that on to Ms. Cabrera, and she can reach out to you, assuming she's the one who gets appointed to represent you, and have that conversation about waiving arraignment so that you don't need to come back here. You will need to come back here at some point, either to have a trial or resolve the case, but I'm all for minimizing the back and forth. It's really be here only when necessary. And I'm sorry we didn't have a lawyer here for you. Sometimes, especially at the start of the year, it takes a minute for the system to catch up with the calendars. But obviously you and Ms. Bennett cannot have the same lawyer. So we'll figure that one out. And Deputy Gordon, once he gets your phone number, email address, we'll get that to Ms. Cabrera, then you're free to go. Deputy Gordon, this gentleman right here, he's gonna bring you a little note card, and you can write down legibly a good phone number and a good email address. All right, Vincent Moore.
And Judge, may I be excused? These are my.
I'm sorry, did you have anything else? Yes, you may. Before you go, anything else I need to know about either of your two cases?
Nothing, Your Honor.
Okay, great. Well, you'll get that scheduling order. That'll trigger a deadline for you to get discovery to the lawyers. Obviously, you're going to have to hold off on Ms. Taylor until we figure out who that lawyer is, but let's get Ms. Feely loaded up with discovery, okay?
Will do. Thank you.
All right, free to go. Thank you. Second call for Vincent Moore. All right. Ms. Clark, bench warrant for Mr. Moore.
Yes, Your Honor.
All right. Hey, Ms. Taylor. No email address? Thanks. Joseph Cooper. Is that your case, Ms. Clark, or is, I'm assuming it is because Mr. Salmon got off the call. Ms. Clark?
Yes.
Mr. Cooper is? Number 5?
Yes, Your Honor, that's my case.
All right, bench warrant?
Yes, Your Honor.
All right. Curtis Hines. Who's handling Mr. Hines? Hello, Ms. Wood.
Good morning, Judge. Happy New Year.
Happy New Year. Should we bring Mr. Hines out?
If we could hold, I sent Ms. Clark an email just now. I want to see if we can work this one out today.
Great. That would be progress. So we'll hold on Mr. Hines. He's up. How about Jabrail Thomas?
Your Honor, subject to notice, the state will move for a bench warrant.
Good morning, Ms. Willingham.
Good morning. And that concludes my business. May I be excused?
Sure. I'm assuming, Ms. Feely or Ms. Wood, if you had contact with any of these names, you, hey, I just talked to the guy, and are some of these old conduct? I mean, it's sort of what we're seeing with I don't know that Mr. Thomas's is necessarily, but anyway, he's not here. All right. We'll do a bench warrant for now, Ms. Willingham, and you are.
Here, I'll be down in Judge Eaton.
Got it. Okay, thank you. German Marufo.
Your Honor, a waiver of arraignment was filed in that case on December 11th.
Oh, okay. Let me take a look. I have Ms. Marsh's name on this, but didn't seem like her kind of case. It should be yours.
This is
All right.
also, Your Honor, that this case was the fact of the indictment. I plan on getting it presented to the grand jury next week for re-indictment. It's just the wording is poor on this particular indictment.
Oh, is that why? I see there's already a demurrer in there. Did that attack?
I believe so, Your Honor.
No, it's the real vague demur, but let's see what we've got. All right, I see the waiver, and his client signed it as well. And the indictment. Okay. All right. So you'll get discovery. We'll do a scheduling order and you'll get discovery to Mr. Lee.
I believe discovery has been, initial discovery was served on December 20th.
Oh, great. You're ahead of the curve. Yep, that's the last thing in the docket was a certificate of discovery. We'll still do a scheduling order, and we'll see what happens from there. Thanks.
And if you could return when the court ready to position 5.
We can do it right now. Position 5 is Joseph Cooper.
So Stephen Reba filed a waiver yesterday.
Oh.
Me running this calendar, so it just came to my attention.
Well, look at that. So they're really supposed to let us know that. All right. Okay, so no bench warrant for Mr. Cooper. I guess I hadn't excused him, but he's got a lawyer now. So we'll do a scheduling order, Ms. Clark, and see where that goes.
We can return to position 4 as well.
All right, hold on.
Sure.
So did you know about all these waivers? I mean, if Mr. Reba doesn't tell you, I don't know how you're gonna know. Okay, so That's Joseph Cooper. What, and you wanted to go to number 4?
So Mr. Moore is also a transfer case for non-complex, it appears, and based on how this calendar's going, doesn't seem like my office is handling those very well, but I do note that Mr. Moore changed his address on December 12th of last year. So that doesn't seem like somebody who was.
Look at that he's actively, he is actively staying in the mix. And he signed it. So we should reserve on that one. Okay. Thank you for checking that. All right. So what? Now I'm confused. What did we do? Was Curtis Hines? Oh, that's who you're going to talk to. Got it. So how about Jamie Maldonado?
Judge, this will be my case. It's a 2021 incident and no good numbers, unfortunately.
Okay. Is this your case, Ms. Clark, or would this be Mr. Jordan's?
This is my case, Your Honor.
All right. What's your thought about notice to Mr. Maldonado?
Your Honor, pending the notice, the state would request a bench warrant ground forfeiture. He was arrested, I believe, the same day of the incident.
Okay, but you agree that the incident was a long time ago?
Yes, Your Honor, it was.
Okay. All right. Position 10 is Mr. Montgomery. He is also 2 of the positions on our add-on calendar. Ms. Cabrera represents, so these are cases 3, 4, and 5 for Mr. Montgomery. I confirmed he is in no bond status now. So I guess do we need to confirm that she's taking?
She's gonna handle them. She said, upon her return, I believe she's gonna find them.
Okay, great. Is Mr. Montgomery here? Okay. All right, I'll talk with him real briefly. In a second. David Daniels. I'm just looking up his indictment. Oh, it's got to be old because he got a bond in 21. Okay. Any luck contacting him from the public defender's office? Not so much. Okay. All right. Well, Ms. Clark, I'll issue a bench warrant if you request one.
Yes, Your Honor, state request bench warrant.
Marcel Copeland.
Judge, he's mine. I'm going to do a waiver, but it looks like there's a second case that needs to be brought over to us from Judge Barwick. I have the number when you're ready.
I'm ready.
Okay, 23 SC 191794.
That's a lot of numbers higher. Wonder 794. Huh. Okay. So do we need Mr. Copeland to come on out?
No, Your Honor, I'm going to go speak to him after the call of the calendar,
Okay.
and I'll get the waiver filed today.
Waive and schedule and
And I'll do the waiver on both if that's fine.
please do. I mean, we should take, and grab Barwick case. Great. Okay. And it looks like I just made it go away, but I don't know if it's this, well, They seem like similar cases.
Yes.
Okay. And those will be your cases, Ms. Marsh?
Yes, Judge.
All right. Will you be handling the one from Judge Barwick as well?
Judge, likely not, well, I personally know I will not be handling it, but, it's.
Your unit.
My unit will, yes, Judge, but I believe that, it'll be technically a trial division case. The charges are terroristic threats and simple battery.
Right.
But I'm sure we'll probably take it. We'll work together.
Okay.
To get a bundle of laws, Judge.
The alleged victim is Sylvia Franklin. Is that the same person who is the subject of the aggravated stalking?
Yes, Judge.
Yeah, okay. So hopefully you guys will work closely together. Okay, got it. All right, Juan Galaro.
He is in custody, Your Honor. I've spoken with him and we are going to be waiving formal arraignment. And he doesn't need to be brought out. I've spoken with him this morning. He's co-defendant though with petition 14, Mr. Romero, who is also here. I've spoken with him and qualified him, but he will need conflict counsel.
And Mr. Romero is out here?
Yes, and he requires a Spanish attorney.
Got it, okay. We'll need to line up Ms. Cabrera or someone. Okay, all right. So what can we do in the future? I know we're coming right off a break, so I'm not drawing lessons from today, but in the future, to flag in advance, so that, and Ms. Cabrera's not available today anyway, the conflict situation. I mean, it's obvious because they're co-defendants, but I can't tell based on the names because they're folks who were active in first appearance or whatnot, which one was PD or conflict or what. What's a good way for us to try in advance to have Ms. Cabrera available to say, yep, I'll be able to take Mr. Romero or Ms. Taylor, et cetera?
So I think this is a today problem really because you was flagged, but I had been back and forth with Ms. Cabrera and I knew she was on.
Okay, got it. Okay. Mr. Romero, do you understand enough English for us to have a small conversation? Poco? Okay. Your lawyer's not here today. I need your phone number and your email address so I can have that lawyer call you. Okay? While we're getting that, let's go to the last position on the big calendar, and that is Siani Carter. I know Mr. Richardson is here. I saw him. Yep, he's here. Good morning, Mr. Richardson.
Good morning, Judge. Happy New Year.
Happy New Year to you. Where is your client in court? Yep, she just stood up and is waving. Hey there. All right, so Ms. Carter, did I pronounce your first name correctly? Okay. Ms. Carter is here. What are we doing today, Mr. Richardson?
Judge, I don't represent her on this case. I represent her on 21 CP 203-820 for a bond pre-indictment. And when I got an email from Ms. Nelson today, kindly, I appreciate it. I wasn't even sure who it was. So I informed her, I think her husband called me maybe 2 weeks ago, a week ago, that she needed to make contact with the public defender's office because he was involved in a serious car accident and has just started walking again. And I think she's a homemaker.
Okay. You handled this in its CP version. It looks like
Right.
the complaint underlying it was 203-820. Was that the number you just said?
When I looked at it, I saw 21 CP 203-820.
Yeah, that's right. So same one. That's this case, but now it's indicted. So I'm following you. You
Yes,
helped Ms. Carter in the pre-indictment phase of proceedings. That's what she retained you for. Here we are post-indictment, and she either needs to retain you again, or if she qualifies and wants to, she needs to get appointed representation.
That's correct, Your Honor.
Got it. Okay. Because this is from a long time ago, August of 2021. All right, Ms. Carter, it sounds like we need to talk about lawyers. Do you plan on trying to rehire Mr. Richardson, or you do? Have you had a conversation with him yet about what that means financially?
Yes.
And it's something you think that your family can afford?
Yes, sir.
Okay, how much time would you need to retain Mr. Richardson? Okay, Mr. Richardson, I don't know if you were able to hear Ms. Carter, but what she shared was that, in fact, she feels like she understands what the financial obligation would be to retain you for part 2 of this case, and that she intends to do that. And she asked for a few weeks to make those arrangements. Is that news to you, or have you had some basic conversations about that?
Judge, what I informed them was that I really didn't have a payment plan per se, and that my intent was to kind of retire from trial work by the middle of this year. So if they couldn't make the lion's share of the payment within the next couple of weeks, because pretty much June 1st, I'm done.
Uh-oh, okay.
Right, so I'll.
So we need to load it up now.
Right. So we need to do it now so we can go ahead and move it along and get it resolved. Because I don't intend to drag any of my cases. I want to close them all before I exit stage right.
Got it. Okay. Well, that makes sense. So what I'm going to do, Ms. Carter, is reset this once for about a month, and that'll give you a chance to talk with Mr. Richardson. It looks like, would want to have most of the payment up front because his law practice will be why I'm envious of him. His law practice will be winding down in the middle of the year, and then he's going to go cruise the world or build motorcycles. I don't know what he does with his free time, but he's going to do it. And he's earned it. So he'll do that. If you can't meet those financial obligations, that's okay. That doesn't mean you're in trouble. It just means when you come back here, then either you need to have a different lawyer with you, or I'll have you speak with either Ms. Feely or Ms. Wood about appointed representation, which is still fine representation. You're not going to, oh, no, now I don't have a good lawyer. You'll continue to have a great lawyer. What I don't want to do is drag this out more. What you supposedly did was 3 years ago almost, and we need to get closure for you. We need to get closure for whoever Shantia Bell is, because something supposedly happened to her, and we're just getting all these new indictments, but it's old facts, and I'm sure you're ready to put this behind you. Mr. Richardson can help, but only if you're able to meet his financial requirements. So do we have a new date yet, or no? Okay. Let me see what we've got for an address, because that's tricky too with these old cases. I have 2 different addresses for you. One is in Jonesboro and one is in Hiram. On Hawk Drive?
Yes.
Okay, we'll use that address. And mail will go there, but we'll for now keep Mr. Richardson on as well. I have to let him withdraw, and I will if you can't afford him. I'm not going to keep him on there, but you all can have that conversation, see if you can work it out. And if you can't, like I said, either you need to bring a different lawyer or be prepared to sit down to chat with Ms. Feely or Ms. Wood about how appointed representation will work. Okay?
Yes, sir.
Any questions about any of that?
No, sir.
Okay, so you'll get something in the mail at that Hawk Drive address, letting you know when you need to be back here. Like I said, it'll be about 30 days, so it would be in early February or later. It won't be before then, so you've got enough time to try to sort this out.
Thank you so much.
All right, Mr. Richardson, anything else?
No, Judge, if something happens prior to that, I'll let Ms. Nelson know.
Great, appreciate it. Sorry to hear your news.
Yeah, well, you got to do something else after 30 years, right?
There you go. All right, take care. All right, Ms. Carter, you are free to go.
Thank you.
And Mr. Romero, you can go too. I've got your information. A lawyer will call you. So I think all we've got left is Mr. Pulley. We'll talk about his situation, and then you want to talk with Mr. Hines to see if we can sort something out. there. Did I miss anyone else? I don't see anyone online. So if we could keep Ms. Jackson and Ms. Tucson on, just in case we're taking that plea, we'll sort that out. Let's talk about Mr. Pulley. Mr. Pulley, if you'll come sit with your lawyer, we just need to get on, hear from Ms. Wood about why you missed court before and see if there's any issue with that. So let me just get his case up. So there was plea and arraignment in November, very end of November, and Mr. Pulley wasn't here. Take it from there, Ms. Wood.
Thank you, Judge. So I was contacted less than a week after that date from his mother, letting me know that she'd been trying to find a number for me, and let me know that he had been hospitalized on that day of court. I did provide that proof to Ms. Clark and Ms. Nelson. Since that time, Mr. Pulley went directly from the hospital into a program. I believe it's in LaGrange. That is where he's actually staying at now, and that's where he's here from today.
This is a program that helps Mr. Pulley with what? Is it a substance abuse treatment program or a vocational program or?
All of the above, Judge.
Okay.
It is Valley Rescue Mission is actually in Columbus. I remember working with them when I worked in Carroll County. So he's there, and of course they do let him go to appointments such as this. And
Yep.
also he went to a job interview this week, got a job.
Great.
So he is on the right track. So we're asking the court to set aside the bench warrant, but I also want him to stick around because I want to talk to Ms. Clark to see if this might be something that we can resolve today.
Yeah, let me take a quick look. Sure, it involves an alleged hotel room theft from a year and a half ago. So maybe so. So why don't you stick around, Mr. Pulley? Let me first find out from Ms. Clark if she's got any objection to setting aside the bench warrant. It sounds like I didn't see it. I don't need to see it. You saw the evidence that Mr. Pulley was actually in a hospital when we had plea and arraignment.
Yes, Your Honor, the state has no objection.
Okay, then I'll set aside the bench warrant, which is good news for you, Mr. Pulley, and then I'm gonna take a quick break while you all talk about Mr. Pulley's case as well as Mr. Hines's case. And then I think I said I would talk with Mr. Montgomery, and you can just bring him to the door because Fields isn't here. Is that right? Great, okay. So I'll just tell Mr. Montgomery what's going on, and then I'll take a break till you all are ready. Did you have anything else, Ms. Marsh?
No, Your Honor, but if I could meet with you in your chambers during the break.
Sure. And you, Mr. Jordan? Just hanging out, enjoying the good life? That's what 8D is all about. So I'll tell you what is circulating amongst the judges is this footage of that courtroom in Las Vegas. My gosh. I told Deputy Gordon, be ready. I want to see a deputy coming sideways. That linebacker hitting that running back. No touchdown. Yeesh.
And it took so long for someone to.
Hey, Mr. Montgomery, I'm Judge McBurney. I just want to let you know why we brought you over here today, so you're not wondering what the heck's going on. So you and I already have 2 cases, and you've got Ms. Cabrera as your lawyer. Turns out you've got 3 more cases to bring to a total of 5. And today I was going to figure out if Ms. Cabrera was going to work with you on those, and then we were going to handle your arraignment. I didn't realize Ms. Cabrera is on leave. It's the very end of her leave from the end of the last year. So she's going to look over the case files. It sounds like she'll probably take them and file a waiver of arraignment, and then she'll be your lawyer for all 5. I just wanted you to know that's why I thought she was going to be here. She couldn't, but that's why you came over today. So she should be in touch with you soon, assuming she's going to take the other 3 cases as well. All right. You too. All right. Let's go talk, Ms. Marsh. And I will mute things in here so you all can. All right, we should be live again. Good morning, Ms. Rivers. Happy New Year. Can you hear us?
Good morning, Judge. Yes, I can. Happy New Year.
Great. All right, so where we left off, we had Mr. Pulley in the midst of his program in Columbus, and we have Mr. Hines. But what Deputy Gordon told me was 1 plea, 2 waivers. I didn't count that many cases. But that's all right. We'll do whatever. Who are we waiving? Let's do that first.
I apologize. I probably already announced the waiver on Mr. Copeland. So that will be a waiver. And then also Mr. Hines is not quite ready to work out, but I do feel confident we can get that one resolved soon.
All right.
And Mr. Pulley's pleading.
Great. So Mr. Hines is a waiver. Does he need to come out, or he was happy seeing you?
He's fine, Judge, and Deputy Gordon is kindly passing a note for me. So.
Okay. Thanks for passing notes. Waive and schedule, Mr. Hines. And when you said Copeland, is that Cooper? No, that's not Cooper. Maybe there is a Copeland. I just want to.
I think it's Marcel Copeland.
Oh, yeah. We got that. You're right.
The guy that has the case in Barwick as well.
Yes, that you found and will be heading our way. Okay. So to recap, before we do Mr. Pulley's plea, it looks like we've got bench warrant on position 7. That's Ms. Willingham's case. Position 9 and position 11. So 3 bench warrants. And I'll work with Ms. Nelson and she'll work with the DA's team and we'll go from there. Okay. Then Mr. Pulley, if you would come up to the podium, we're going to handle your plea right now. Ms. Clark, are you ready?
Yes, Your Honor.
Great.
And Your Honor, if I may, I did have one question for the court in regards to the pretrial calendar for later today. Deputy McCauley is currently out sick, but she wanted to make sure that Michael Reynolds was not going to be discussed later on this afternoon, which is with Attorney Shepard, and I believe that's already specially set for January 22nd.
Right. I mean, it wasn't going to be not discussed. It would just to make sure that that was still something that folks were ready on. So if you can just confirm that she's ready, and then you can just send an email to me and Ms. Nelson. And if she has any intel, we cleared this with Mr. Shepard's calendar as well, so it should be something where everyone is ready. Hopefully, Ms. McCauley's ailment won't prevent her from being, that's a few weeks away, so. But that's the only way we'd bring it up is, hey, this is supposed to go out the first week. Any reason why it wouldn't? And then obviously we'll have to have some backups. And we have a speedy trial demand, which sort of throws off some of these special settings. So, but she does not need to emerge from sick bay to attend.
Thank you.
Sure.
May I be excused?
You may, thanks.
Judge, I have a question about this case, or related to this case as well.
About Mr. Pulley or Michael Reynolds?
No, Mr. Pulley.
Okay. Do you want it on the record, or you just want to talk before? Okay.
There's a probation case, I believe it's out of Judge Glanville's courtroom, 14 SC 127358. I cannot remember if Judge Glanville is a judge who is glad to let you.
He is.
Okay.
So we'll address that as well. Great. Okay.
That means that because your revocation, whenever you had it, was not including this charge. We're gonna handle that today. Okay.
All right. Are you ready, Ms. Clark?
Yes, just 1 second, I wanted to pull up the, for the factual basis.
No problem.
Okay, Your Honor, the state's ready.
Okay, let's get on the record. before we get started, can you adjust that monitor a little bit? We're catching Mr. Pulley's chin. If we could point it up a little more, it'll be easier. Perfect. Okay, great. We're getting on the record in case 23 SC 190082, State versus Justin Pulley. Mr. Pulley, you are charged with burglary in the second degree in this case, and Ms. Wood tells me you're prepared to enter a plea. Is that correct?
Yes, Your Honor.
Okay. In a moment, Ms. Clark, the prosecutor, is going to put you under oath. Once you're under oath, you'll need to answer all of Ms. Clark's questions truthfully and completely. You should let me know if you've got any questions of your own. There may be things you speak about in confidence with Ms. Wood, or there may be things I can answer for you, but you need to let me know that there's a question so that we can pause whatever we're doing and try to answer your question. Will you do that?
Yes, Your Honor.
Great. When you're ready, Ms. Clark.
Thank you, Your Honor. And also, for the record, the state will be reducing the charge burglary in the second degree to criminal trespass under 16-7-21.
Thank you.
Defendant Pulley, please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am, I do.
You can put your hand down. Please state and spell your correct legal name.
Justin Dean Pulley, JustinPulley.
Are you at this time taking any medication or under the influence of any drugs or alcohol?
No, ma'am.
Is there a medication that you normally take that you've not taken today?
No, ma'am.
How old are you?
46,
What's the highest level of education or the last grade you completed?
some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have been charged with the following offense? 1 count of criminal trespass under 16-7-21.
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
I do, ma'am. Yes, ma'am.
I'll need to go back. Do you understand that you were originally charged with burglary in the second degree under
Yes.
the indictment?
Yes,
But
ma'am.
the state is now going to reduce that to criminal trespass.
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Could you repeat the question?
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
Has Attorney Wood advised you of the minimum and maximum sentence to the charge of criminal trespass that which you're pleading guilty today?
Yes, ma'am.
The state will provide that information. The minimum is 1 day in jail. The max is 12 months in jail. Do you understand that you are entering what is called a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For a plea of guilty in criminal trespass, the state's recommendation is 9 months to serve, commuted to 12 months to serve. And we're going to commute it to the time that the defendant served in custody, which was 291 days. Is that your understanding of the terms of the plea agreement?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am, I do.
Are you currently on probation or parole?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am, I do.
Are you a United States citizen?
I am.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am, it is.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 23 SC 190082, how do you plead to the single charge of criminal trespass?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
For a misdemeanor charge, you would only have 12 months from today's date to file that petition.
Yes, ma'am.
At this time, Your Honor, the state will provide a factual basis for the misdemeanor plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on June 11th of 2022, at the incident location of 35 14th Street Northeast, Atlanta, that officers arrived on scene and met with the victim, Mr. William Stoney Lamar. Mr. Williams said he rented the hotel room number 1203. His friends went to the store. When they advised that they were on the way back, he left the hotel room door cracked open so that his friends could enter. Moments later, Mr. Williams' friends told him that they could not access the door and that their keys were not working. Mr. Williams went to the room and tried his access key. It did not work either. He contacted security, but security's keys did not work as well. They asked if anyone else had access to the room. Mr. Williams advised security that he did not. However, Mr. Williams noticed that the peephole went dark as if someone was looking through it. Mr. Williams started speaking through the door and advised the person that if he came out, Mr. Williams would not press charges. No one answered. Mr. Williams continued saying that he knew someone was inside the room and that the person needed to come out. A white male wearing a gray shirt, khaki shorts, came out of the room. Mr. Williams held him and brought him down to security. Officers later identified the male as the defendant in this case, Justin Dean Pulley. Mr. Williams said Mr. Pulley went through their luggages, but nothing was missing. He also checked Mr. Pulley and did not find any property on him. Officers spoke with the defendant. He said someone made a room arrangement for him. He came to the location to meet with a woman. He was scared when Mr. Williams came to the door. Your Honor, after conferring more with the victim and the defendant was taken into custody and arrested for the charge of burglary in the second degree. Your Honor, after speaking with Attorney Wood and her providing me the mitigation information regarding the defendant, the state feels that this is the best resolution for the case. We were happy to hear about Mr. Defendant Pulley's progress as far as the program that he's actively in. And so based on that basis, we were willing to come to that resolution.
Okay, thank you. Good morning and Happy New Year, Ms. Jackson. Can you share criminal history information with me, please?
Good morning and Happy New Year to you, Your Honor. He has 50 cycles.
50 or 15?
50.
Thank you.
And the last arrest was March the 28th, 2023 in Snellville, Georgia, for a failure to appear The underlying charge was giving false information to an officer and obstruction of an officer. He does appear to be on probation in Snellville, Georgia, for giving false information to an officer and obstruction of an officer. That disposition date was March the 29th, 2023, and the term is for 12 months. He does have prior felony convictions, one in 2014 for criminal damage to property in the second degree and obstruction of an officer. So another one in 2014 out of Bibb County for burglary in the second degree. There was one in 2010 out of DeKalb County for aggravated assault. One in 2009 out of Cobb County for Terroristic Threats Act. And one in 1998 out of Florida for burglary. He does have misdemeanor convictions. It's one in 2021 out of Muskogee County, Georgia for stalking. One in 2019 out of Alabama for theft of property. One in 2016 out of DeKalb County for theft by shoplifting. One in 2008 out of Muskogee County for false report of a crime. One in 2006 out of Muskogee County for theft by shoplifting and a DUI. Another one in 2006 out of Alabama for larceny. One in 2002 out of Florida for petty theft. One in 2001 out of Florida for DUI. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, we'll talk more at the, well, I guess we won't talk at the end because there's not a felony disposition here. Well, I guess we'll have to talk about the 14 SC case. How many, first of all, Happy New Year to you. How many cases does Mr. Pulley have active probation? For how many does he?
Hi, Judge. He has just this case remaining. There's 2 months and 11 days remaining on it.
When you say this case, the one ending in 358?
14 SC 127358, correct.
Okay. The other case we heard about from 2014, Bibb County burglary, that's not an active probation matter?
You said Bibb County?
Yeah, Ms. Jackson flagged another felony from 2014, and he may not have been put on probation for that. I just don't want to leave Mr. Pulley with the impression that we're handling all his felony probation today if they're non-Fulton cases that are open. But what you're saying is the only open felony probation that you see in the whole system is the 14 SC case.
Yes, that's correct. The Bibb County case expired.
Okay, great. Thank you so much. So, Ms. Wood, tell me what's going on with Mr. Pulley. That's a pretty extensive criminal history, mixed bag in terms of violent, non-violent. We've got this hotel room situation, and he's getting treatment now.
Thank you, Judge. So yes, I think if I heard correctly, it was like the last aggravated assault. The only aggravated assault conviction is over a decade ago. It seems from my speaking with Mr. Pulley and speaking with his family that most of his interactions with the criminal justice system stem from his struggles with addiction and also some mental health concerns. The court date that he missed, he was at Peachford. He went directly from Peachford into their version of a transition. I believe it's called the Lodge. And then from the Lodge, he went directly to Valley Rescue Mission. He will be there for at least 3 months. And he also this week was offered the job at Alexander Electric. He starts on January the 8th. This incident was from, again, it stemmed from being under the influence and being confused about whose room he was actually in, Judge. He did serve 290 days for this case. He tells me he lost everything due to those 9 months he had to serve. He ended up becoming homeless, and then that, of course, just contributed to the cycle of using to get by. He is 46. He does have some college education. He is trained as an electrician. That's what he will be doing with Alexander Electric. I believe Mr. Pulley is eager to finally get everything on track. And so we just ask that you accept the state's recommendation in this case.
Okay. Mr. Pulley, I have a few questions. So the job that you got, it sounds like, will draw upon your professional skills because it was something electric. You'll be doing electrician work for them?
Yes, Your Honor.
And does that mean you'll be going to job sites where? Because I noticed in looking at your older case here, Judge McAfee, who inherited, I think, Judge Glanville's criminal docket, entered an order just a few months ago revoking your probation, and part of it included that you be reinstated, and you were going to be able to go to Alabama to work. That's a different job, though. You're not. What kind of work was in Alabama?
Able Electric.
So also electrical work.
Yes, sir. But unfortunately, just with the short time of my felony probation, it ends in April. The interstate compact is time sensitive matter with probation ending in 4 months. Your Honor, when I'm doing right, everybody loves me. Employers, people, I love me when I'm doing right. And so that's been a light in my life. When I come back and I come back out of the darkness, hey, you're back. Can we get you? So I have no problem with employment. And so Alexander Electric is an employer I used to work for, which is in Columbus, and that's who I contacted and said, I'm back. Can I work?
Okay.
That's where I'll be going.
And will work for Alexander Electric mean that you have to travel around the country, or?
No, sir. Ironically, I'm start helping at the project's called Riverfront, the sheriff's department.
All right. Well, there'll be someone watching you. Okay. What is it that you struggle with the most in terms of addiction?
Your Honor, the drugs and alcohol are really just a symptom of deeper issues. Growing up, I used to be really wild, my background. I just had trouble with dealing on life's terms. In AA, in Alcoholics Anonymous, they call it the king baby syndrome, to where I want it my way right away. And
sure.
I guess getting older, I have some gray hairs on my goatee. Some wisdom has been starting in my life. And I know not all Jesus's miracles were instantaneous. I'll just say that. And this felony was my only felony I've had in 10 years, this second degree burglary. So I got a little bit of a track record of trying to get things right. And like I said, I'm getting a little older and wiser, and I can't risk going. I have found that when I become a stand-up guy and live like accordingly, there's no better feeling than that I have tried to seek and find in the world through a drug, through a drink, through a woman, through a dollar. And that's what I'm holding on to. And that's what keeps me getting back up after I fall.
Okay. So when you are self-medicating through alcohol or drugs, what kind of drugs? Do you have a drug of choice? Did you have a drug of choice?
Yes, sir. It goes alcohol and then methamphetamine.
Okay. Housing. You currently are living at Valley Rescue Mission?
Yes, sir.
If you continue to be the stand-up guy you want to be, and that the thing that feels good, you'll eventually need to move out. Do you have family or friends, or you would be able to stay at Valley Rescue Mission until you could financially afford to live on your own?
I'm a pretty seasoned electrician. I get paid pretty decent. It's a minimum 9-month, maximum 6-month program. So the fees there are $75 a week, and the director strongly encourages save your money.
Sure.
So I don't see an issue with me being able to financially support myself when it's time to.
How many months have you already been at Valley Rescue?
I left from the Peachford Lodge December 27th, and I was entered into Valley on the same day.
So you're brand new there. You have up to 9 months should you want to stay there that long.
Up to 6.
Oh, okay.
6, yes, sir.
Got it. Up to 6 months. And then you'd need to transition to your own housing.
Yes, Your Honor.
Do you have family in Georgia?
My brother, yes, Your Honor.
Is your brother a good resource for you or a source of distraction?
I was the black sheep. He's a very good resource.
Where is he?
He's the CFO for Knox Pest Control, based out of Columbus.
Okay. All right. And are you on speaking terms with him now?
I am.
Does he know you're at Valley Rescue?
Yes, sir.
Okay.
And my parents, they live right across the border in Valley, Alabama. And they're, you know, God's putting my family back together, you know, and it feels wonderful.
Okay.
My mother and stepfather back in my life.
All right. Well, here is what I'm gonna, well, first, I find there's a factual basis for your plea. It sounds like you were in someone else's hotel room, and the fact that you were voluntarily intoxicated is not a defense. It would explain what happened. It just doesn't justify what happened. It may have been a little overcharged, not by Ms. Clark, but originally you were not in your hotel room, but you didn't take anything. Did this Mr. Williams guy basically just detain you? Was he a big guy? Because the way Ms. Clark was describing it, he made sure you didn't have any of his stuff in your pockets. And I was just thinking, like, I wouldn't be going in your pockets. I'd be calling, hey, hotel security, come deal with this guy. Sounds like Mr. Williams just dealt with it himself. Was he a big dude?
Yes, Your Honor. I have no excuse, zero, and I want to apologize to the court first for this, just wasting everybody's time like this. You know, I was under the influence. I kind of ended up in the room and went to sleep on the floor. But I entered the room and I didn't see anything. It was a brand new, freshly, and no, I didn't see no luggage. I wasn't searching for luggage. This was
Okay.
not
I'm not asking you to minimize or max out. I was just curious what your interaction was like with Mr. Williams.
There was initially at the door.
Yeah.
And then him and his friends, hey, let's go downstairs. The police are waiting for you. And we all accompanied each other downstairs.
Okay. All right. So they didn't throw you down the stairs or anything?
No.
Okay. All right. Well, as I said, Mr. Pulley, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. This is how you want to move forward. And knowing means you've understood the things that we've been talking about. Do you agree with both those things?
I do, Your Honor.
Great. Then I'll accept your plea. I'm going to propose a different sentence, but let's talk about it. I am more comfortable with a sentence of 12 months to serve 9 months, credit for time served, so you're not going back into jail, but 3 months of misdemeanor probation with one condition. And that condition is that you continue to participate in the Valley Rescue Mission. And here's my concern. You are 46. I think you're beginning to turn the corner of, I need to live a different lifestyle because it could kill you otherwise. Williams could have cracked your head open and people would have said, hey, there was a stranger in his hotel room. I appreciate your observation that until this, which is only a borderline felony and is being played out as a misdemeanor, you had stayed out of the big trouble, but there's still you in Snellville and false info, and you're clearly still struggling with some things. And I'd like a little safety rail, knowing that if you walk away from Valley Rescue Mission, maybe I get notified about that, and that's where probation would come in. However, I don't want to impose probation if that's going to interfere. I know Judge McAfee had to jump through a bunch of hoops here so that you could work in Alabama, but like you learned with interstate compact, that wasn't going to work. I don't think the same applies with misdemeanor probation, but I'm going to let your lawyer weigh in. And again, the only reason why I want the probation is to have a little bit of enforcement mechanism. If you decide, because you've only been there for a week now, if you decide 2 weeks from now, I'm too big for the Valley Rescue Mission, and you go out on your own, you're not ready for that. And the value of this program is some continuity and you committing to that. So that gives me that level of comfort. Your thoughts, Ms. Wood?
I don't hate this proposal, Judge.
Right, well, that's a start. She doesn't hate it.
I'm just wondering, but the only thing like gives me pause is I know he's already plugged in for this 14 SC case with felony probation. I know he's
That's about to end.
How many months? I think I missed it.
Well, I'm about to close it out.
Oh, you're gonna close it out.
I want to close that out.
Okay, because I was gonna ask you if you were gonna leave it. I was gonna see if the revocation could be like a condition.
Oh,
Like the Valley Rescue be a condition of that.
of that, yeah.
I just know that misdemeanor is separate from felony probation, and sometimes those wires get crossed.
I like that more. I like that more. Since I have the revocation tool, it's a little less than 3 months, but it's 2 months and some days. And so I'll just reinstate him. I'll find that he violated his probation, reinstate him on, and I'll say it officially in a minute. And it'll be slightly shorter period, but that's easier. It's harder if you're thinking you're going to need to work in Alabama, because you can't. You've learned that.
Yeah, but I'll discuss with you why that's not the best idea. Okay. So Judge, I think it makes more sense in my head for it to be the conditional on the felony probation since he's already locked in.
Me too, and that's what I'm doing.
Okay.
I mean, it's not even though your lawyer said she hated it, she actually doesn't make the decision, but she gets to give me good thoughts, and this was a good thought that we ought to tie it to the felony probation. So amendment, your sentence in the case to which you just pled, ending in 082, is 9 months to serve, credit for time served. And you did about 3 weeks more than 9 months. So you've resolved the second degree burglary as reduced by the state to criminal trespass. I'll sign that. However, this new plea and this conduct is a violation of your probation in 14 SC 127358. And your lawyer has asked that I address this, so you've waived your due process notice rights. I will address it by saying that I find you violated your probation in that old 14 SC case through this new plea. I'm not going to revoke any time. I'm going to reinstate your probation and add as a special condition, and special simply means if you violate the condition, I can revoke everything. Everything is right now 2 months and counting. So you'll be done with your felony probation by the end of February, maybe a little into February. But I'm adding as a special condition that you continue to participate in the Valley Rescue Mission program. So you don't get a quit. Now, if they kick you out, that's also a problem, and that would be a violation of your probation. But if they are supportive of you staying and you have impulses that are pulling you away, just know that that'll be a violation of your probation. That'll come back to me, not Judge McAfee. It'll come back to me, and I will likely see that as a sign that we need something more intensive to help you, not punish you, but help you. I'm hearing you say, and you're using the right words, but I've met many addicts who know how to use the right words so they can leave the courtroom through that door rather than that door. But you're saying the right words. I just need you to walk that walk as well, one day at a time.
Yes, sir.
And it sounds like you've got family support, you've got work support. They want you back at Alexander Electric, whatever it's called. You just need to commit yourself to the program. Okay.
Yes, Your Honor.
Ms. Clark, anything you want to add or you think I should subtract to what we just talked about?
No, Your Honor.
Okay. Ms. Tucson, do you need any information from me or from Mr. Pulley?
Okay, so basically, I don't need any information, but I sent you a message about that case, the 14 SC case. They just had a hearing about it.
Yep, I'm seeing your note now.
Yeah, so they're submitting a warrant cancellation to the court. Chief Joyce just put that in, and I called him while we were on pause. So do you want them to continue that warrant cancellation to go through and the probation will expire, or how would Chief Joyce said it is completely up to to judge?
Sure. So I do not want Mr. Pulley taken into custody on the warrant. I don't want the probation to expire today. I thought you told me there was 2 months and some change left on it.
No, there is. That the warrant cancellation will cancel the current warrant now, and his probation will end when it's supposed to end in March.
Good. And so what I would like to do is, if you could prepare a revocation order in the 14 SC case that finds that Mr. Pulley did violate his probation through this new plea, but what I'm doing is continuing him on probation, and I'd like that to be supervised. You know, it's only a few more months and it's actually an old case, but I want to make sure that someone is putting eyes on Mr. Pulley to confirm that he's complying with this new special condition, which is that he maintain his full participation in the Valley Rescue Mission program.
Okay, no problem.
Great. Thank you for flagging that. I appreciate your real-time work with Chief Joyce.
No problem.
All right. Do you need any contact information from Mr. Pulley?
You have Chief Joyce's number, correct? Since you just spoke with him, Mr. Pulley?
Yes, ma'am. Yes, ma'am, I do.
Okay, yeah, just make he'll see my case notes as well in regards to this plea and information in. So just make sure you give him a call in a couple days about it, okay?
Yes, ma'am.
So Chief Joyce is a DCS person from Columbus area?
Fulton.
Oh, from Fulton. Okay.
Yes.
And we'll just, because it's only 2 months and a few days, we'll keep Fulton as the geography that supervises Mr. Pulley, because he's going to be down in Columbus.
Yes, and then after all this gets put in, he could also coordinate that with Chief Joyce, and he'll put
Okay.
that in too.
All right. Sounds like a plan. Ms. Wood, anything else?
No, Your Honor, thank you.
Mr. Pulley, do you have any questions about what's happening?
No question, sir.
How did you get here from Columbus?
Groom transportation.
They're going to get you back?
I paid for the round trip.
Okay, great.
Yes, sir.
All right. Good luck with everything.
Thank you. Thank you, Your Honor.
All right. Thank you, Ms. Wood. Thank you, Ms. Clark. This may be one of your last pleas here in 8D as a line ADA.
Yes, McBurney.
Yes, Ms. Nelson?
I'm questioning the time credit for time served on Mr. Pulley. Does Ms. Wood have those dates? Because I'm not seeing it on Odyssey.
I can give them to you because I found them on Odyssey. It is, if I go back to his jailings, he was booked in on June 12th, 2022.
Oh, I see it now. I'm sorry.
Yeah, that's okay. It's that older one.
Okay, thank you.
You bet. So that's it. Thank you, Ms. Jackson and Ms. Tucson, Ms. Rivers. Our afternoon calendar has been canceled. Not the lawyers coming in to talk about the trial calendar, but we had a motions hearing with a gentleman named Fields, and we cannot do that today. So if anyone was coming back on for that, you don't need to. You can do other things. But I will see you two at 3:30. All right, and maybe you and Ms. Feely a little before then?